Okay, hi, Assalamualaikum and a very good day. So today my group will be presenting on the Local Government Act 1976. To the next presenter.
Hi, Assalamualaikum. My name is Nurul Najah binti Sis and I'll be explaining about the background and introduction of Local Government Act 1976. As for the historical background, the political structure of Malaysia is a legacy from the era when the country was colonized by the British. Many of Malaysian law are drawn from the model by English law as a result of the country history as a British colony which left its mark on the countries from the governance. On the other hand, as time has passed, many of the local authorities, social and cultural aspect has an effect on the functioning of the various local government in Malaysia. After the federal and state level of government in Malaysia, the local government, also known as local authority, is the third and final level of the country's government hierarchy. According to the provision of the Constitution of Malaysia, state government are constitutionally responsible for all matters pertaining to local governments. The only exception to this rule is allowed for local governments located inside the federal areas. The state government has broad powers to regulate the local authorities and to ensure that they are both effective and efficient in their work. And there are few rules of local government based on Act 171. According to Act 171, the rules of local government are power of local planning, power to issue a license, power to impose specific taxes, build buildings, residential and commercial units such as markets, stall and whatsoever, power to planning and managing urban areas, manage and control traffic, which includes urban public and transportation system, and also plan and provide public facilities to the public. The Local Government Act of 1976 essentially created just two sorts of local council. One is for urban areas and one is for rural areas. A municipal council may be granted city status by Yang di-Pertuan Agong with the approval of the Conference of Ruler if it meets the requisite condition. In addition to those listed in Act 171, there are several additional agencies with the local council responsibilities.
Assalamualaikum warahmatullahi wabarakatuh. My name is Shazana Alia. So today I will present about the provision to allow the appellant to make the objection. So according to section 142 subsection 1 of the Local Government Act, any individuals who feel wrong by the proposed amendment on any of the following ground listed, which is that any holding for which he is rateable is valued beyond its rateable value. So the second one is that any holding value is not rateable. The third one is that any person who or any holding which ought to be included in the valuation list is omitted. Therefore, the fourth one is that any holding is valued below its rateable value. Or the last but not least, that any holdings which have been jointly or separately valued ought to be valued otherwise can make objection in writing to the local authority at any time not less than 14 days before the time fixed for the revision on the valuation list. The most common grounds for objection are that the property in question is worth more than its rateable value and that the property sought to be charged with rates is not rateable. So section 144 subsection 6 of the Act states that the revised rate arising from a valuation list adjustment becomes so the section 144 subsection 6 of the Act states that the revised rate arising from a valuation list adjustment becomes payable at the start of the next half year or at such earlier date as the local authority may decide.
Okay, hi. Next, my name is Sophia. I will be talking on the right of appellant to make an appeal to the High Court. So basically, this is under section 1455 of Local Government Act 1976, where the right of appellant to make an appeal to the High Court can be referred to section 1455 of Local Government Act 1976, where from the decision of law to the Federal Court, whose decision shall be final and conclusive. So, under this section can be referred to court case of Majlis Perbandaran Seremban v Tenaga Nasional Berhad court case, where the appeal under subsection 145 subsection 5 of the Local Government Act. The appellant is the local authority of the town of Seremban, whilst the respondent is the major supplier of electricity. The defendant had issued a total of 212 notice of amendment to valuation list all dated 30 October 2017 to notify the defendant's intention to impose annual value and assessment rates under Section 144 on 212 pylon belonging to the plaintiff situated within the local authority area of the defendant. And the plaintiff had lodged its objection to the defendant against the imposition of the annual value and assessment rates by giving its jurisdiction. As under Section 145 of Subsection 5 of Local Government Act 1976, it also gave a right of an appeal to the High Court to any person dissatisfied with the decision of the local authority on his objection made under Section 1443. Besides, Section 145 Subsection 5 also provide for further appeal to the Federal Court. Okay, to the next presenter.
Assalamualaikum and hi, my name is Akila binti Jari. So for my part, I'll be explaining the reason to be considered to make an appeal. Any person having or make an objection in the manner prescribed by Section 142 or 144, it is someone who dissatisfied with the decision of the local authority and thereon may appeal to the High Court, and every such appeal shall be heard before the High Court, whose decision and question of the fact shall be final and conclusive. When they want to make an appeal, it is from the decision of the High Court. The party may appeal on the question of law to the Federal Court, whose decision shall be final and conclusive. However, the High Court consider a reason to make an appeal on cases that is related for what has been not agreed by the appellant. For instance, Tenaga Nasional Berhad versus Majlis Daerah Segambat Federal Court Putrajaya. It is a cases that where the appellant dissatisfied and filed an appeal to the High Court by way of originating motion pursuant to the Section 145 of the Local Government Act. The High Court dismissed the appellant's appeal on the sole question raised by the parties. The other cases that we can look into is United Plantation Berhad versus Majlis Daerah Sabak Benar High Court Malaya Shah Alam. The appellant was entitled to file the appeal against the revised valuation list because Section 2 of the Local Government Act defined rateable holding as holding which is subject to the payment of rate made and divide under the Local Government Act. In other words, the rate imposed on the owner of the holding must be lawfully made and divided under the Act. However, the appellant land was not rateable as understood in Section 142 of the Local Government Act. The appellant was entitled to appeal against the revised valuation list to the High Court pursuant to Section 145. That is all from me. Thank you.
Hi and Assalamualaikum. My name is Siti Noordina Aslin. So today I will present about the procedure to make an appeal. In Local Government Act 1976, the procedure to make an appeal has been mentioned and stated in sections 145. For the subsection 1, in section 145 state that any persons who having made an objections in the manner prescribed by section 142 or 144 is dissatisfied or unhappy with the decisions of the local authority thereon may make an appeal to the High Court by way of the originating motions to make an objections. As been provided that with the feelings of the originating motions that shall be paid into the local authority the total amount of the rate appeals again. So in subsection 2 mentioned that the originating motions shall be filed by the person who is dissatisfied with the decisions of the local authority within 40 days of the receipt. So while in subsection 3 state that the local authority shall be the respondent in any appeal under this section. Moreover, in subsection 4, the Local Government Act 1976 mentioned that every such appeal shall be heard by the High Court with decision on question of fact shall be final and conclusive. While in subsection 5 state that from decisions of the High Court at the party may appear on question of law to the Federal Court whose decision shall be final and also conclusive. Okay, last but not least, as mentioned in the subsection 6 of the Act, state that any appeal under subsection 5, any written law for the time being in force relating to the appeal in civil matter from the High Court in its appellate of jurisdiction to the Federal Court shall may be applied. Besides, the respondent hope that the cause of this appeal be taxed by the proper officer of the court be paid by the respondent to the appellants. The respondent had not paid the rate appeals again, but the amount was only be paid on 6 February of 1997, for example, which is 5 weeks later. In the circumstances of the case, the land judge was right to make an order for the extension of time for the respondent to pay the rate as not to frustrate the respondent right of appeals. Through no fault of theirs, the appeal was dismissed and the respondent will get a deposit for their taxable costs. From this, it showed that the decision of the court is final and also conclusive. That's all from me. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Naarifah Fairuz binti Cik Fauzi and I will present about the role and function of respective agency in an appeal proceeding. So the appeal proceedings as stated in the Local Government Act 1976, which is under section 145, is regarding the person who is dissatisfied with the decision made by the local authority. So his or her may appeal for her objection to the High Court. So appeal proceeding is about the give taxpayers opportunities to determine the reasonable of their assessment. So the High Court decides in favour of the tax ratepayers of the excess amount paid to the local authority may be set off for the against to the local authority or refunded to the ratepayer. So the respective agency in an appeal proceeding may be include of city council, municipal council or district council due to the rates to be one of the source of revenue for local authorities that need adequate funds to respond their duties and responsibilities. So apart from that, the role and function in respective agency is when the receipt of the written objection has been made by the dissatisfied person. So the local government is expected to act on it on matter agreed upon. So as according to the court case regarding the appeal proceeding, which is a Majlis Daerah Segamat versus Tenaga Nasional Berhad, decide to imposition of rate by local authority can be challenged where the objection rates does not fall under section 142 of Local Government Act. So this is because of the TNB does not own the land and therefore the High Court allow Majlis Daerah Segamat preliminary objection and dismiss TNB application for judicial review. So further, the Federal Court dismissed the Majlis Daerah appeal with cause.
And I will explain about the conclusion. So for the conclusion, the local government is in charge of drafting, enforcing and also carrying out all administrative work based on the Local Government Act 171. So such as local planning, power to issue licenses, impose specific taxes. Therefore, the appeal and proceedings give the taxpayer opportunities to determine the reasonable of their assessment. This is decided by the research by Emily 2011. Therefore, as taxpayers, we are eligible to condone with any dissatisfaction with the valuation list matters by the following. For example, by the following section, which is section 142, which we may raise the written objections to the local authorities at any time to 14 days before the date set for the modification of the valuation list, based on the subsection 1, followed by the section 144, the reason, explain the reason why the appellant may write the objections. Later, we followed by the section 145, which any person who having made of the objection in the manner prescribed by the section 142 or 144 is dissatisfied or unhappy with the decision of the local authority, thereon may make an appeal to the High Court by way of urging the motion to make an objection. Lastly, city council, district council and also municipal council are the sites are responsible in appeal proceeding to review the revaluation list due to the rates to be the one of the sources of revenue for the local authorities who need the adequate funds to respond duties and also responsibilities. Therefore, when the unsatisfied person submits a written objections, the local government is responsible to act and is expected also to act on the agreed upon matter. That's all for us. Thank you.